Hello, this is Professor Moore with another in-demand review video. This one is going to be on notice to the defendant. I'm not doing a current review video for personal jurisdiction because I already have two of those already on YouTube. So I'm just moving on to notice. I don't have my cool microphone here where I am, so if the sound here is unbearable, please let me know and I will buy another microphone for this place. So we're talking about notice to the defendant, and as I said, we first did the unit on subject matter jurisdiction, and then we did the unit on personal jurisdiction. And this is the unit on notice, and then we did a unit on venue. I think that it is easiest for first-year law students to think of those four things as entirely separate analyses. You need all four of them to have a properly functioning lawsuit. There is some linkage between venue and personal jurisdiction, but I think it's easier and less confusing to just treat them all as separate and necessary requirements. So, in other words, just because you have personal jurisdiction over the defendant does not mean that you've given notice to the defendant and vice versa. So, just as with subject matter jurisdiction and with personal jurisdiction, there is a constitutional element to the notice requirement as well as a statutory requirement. And so the constitutional requirement is thought to emanate from the 14th Amendment Due Process Clause, which of course says in the midst of Section 1 of the 14th Amendment, says, "Nor shall any state deprive any person of life, liberty, or property without due process of law." And of course, that concept, due process of law, encompasses a number of things that we consider fundamental to our jurisprudence, one of those being adequate notice to the defendant of a proceeding against him or her. In addition to that minimal constitutional requirement, there are also statutory requirements for notice in both the federal system and in every state court system. And the notice requirements in federal court are set forth in Federal Rule of Civil Procedure 4. So first, getting to the constitutional standard, the due process standard, the Mullane versus Central Hanover Bank case is still the go-to constitutional standard case in this area, and its holding, or the standard that it pronounced, is on the bottom of page 329 of your casebook. And the Supreme Court held that due process requires that notice be reasonably calculated under all the circumstances to apprise interested parties of the pendency of the action and to afford them an opportunity to present their objections. So this is very frequently abbreviated to the constitutional minimum of notice and an opportunity to be heard. So obviously there's really no point to getting notice if you have no opportunity to be heard. And the Supreme Court went on to say something to the effect of, the constitutional standard is, what if you really wanted the person to know, and you were a prudent business person? How would you go ahead and tell that person? And so if you'll recall in the case, those beneficiaries of the trusts who the bank had current addresses for and knew their current identity, it was not sufficient constitutionally as to those beneficiaries for the bank to simply publish notification of its final accounting in a newspaper, in an obscure publication notice. But it was not constitutionally required for the bank to track down current income beneficiaries that it did not have the current name or address for, or if it had changed and the change had not come to its attention in the course of being diligent. It did not have a duty to track those people down. But for those current income beneficiaries that it knew who they were and where they were, publication notice was not constitutionally sufficient. The bank needed personal, not personal, mail notice to those individuals' last known address. But for people that for beneficiaries who were contingent or their whereabouts were unknown, publication notice was deemed to be constitutionally sufficient in that case. So you wonder, well, what is the relationship between the constitutional requirements set forth in the Due Process Clause and in Mullane and the statutory requirements? Because the constitutional requirement is, very minimal and kind of squishy, the court systems have developed a rather elaborate method of giving notice to various types of entities through statutes. And so you need to have both the constitutional minimum of notice met, plus you need to have whatever the statutory method is in that state or in that court system met. So you need both. So for example, in Mullane, the way that the bank gave notice was through publication. The reason they thought that was okay was that there was a New York state statute that allowed them to do it that way. And so they perfectly complied with New York state statutes, but New York state statute in that particular did not meet the constitutional minimum, which in those circumstances for the current income beneficiaries was mail notice, first-class mail notice. Conversely, even if you give notice that meets a constitutional minimum under Mullane, and yet you have not complied with the specific requirements of the statutory provision that's in effect, then you also haven't given notice appropriate to begin the case against that defendant. So here was our question that we had at the beginning of class a week or so ago. It's a multiple choice question that you should have already seen. So I'll let you pause the video and remind yourself of what the correct answer is, and then I'll move on. So the correct answer here is D. The service may violate defendant borrower's due process rights because it is not reasonably certain to inform the defendant borrower of the pendency of the action. So this is your classic Mullane sort of hypothetical where a lender in a foreclosure proceeding is allowed by state law to serve by publication. The bank complies with that, and yet it is probably, given Mullane and the similarity of Mullane, it is probably going to be unconstitutional under the Due Process Clause. Now let's look at the incorrect answers and analyze why each of them is incorrect. So A is an incorrect answer. The service is constitutionally proper because the federal rules of civil procedure incorporate state service rules of the state in which the federal district court sits. The last part of that, starting with the federal rules of civil procedure, is true. Federal Rule 4 for many entities that you serve does incorporate state service rules, as we will get to later in this video. However, the part that makes this untrue is the first 5 words or 6 words. The service is constitutionally proper because. Again, as I said in the last screen, just because the federal rules of civil procedure are correctly followed does not mean necessarily that the service is constitutionally proper. It is a separate standard. Looking at B, that incorrect answer is the service does not violate the due process clause because that clause does not require actual notice nor personal service of process. So again, the last part of this statement is in fact true. The due process clause does not require actual notice, nor does, as we saw in Mullane, the due process clause require personal service of process. In that case, first-class mail notice was fine constitutionally. What makes this a false answer is that it doesn't encompass the possibility that this hypothetical could still violate the due process clause, even though the rest of it is true. The third wrong answer is C. The service is not proper because the federal rules of civil procedure do not authorize publication notice. Again, the last half of that sentence is right. The federal rules of civil procedure do not authorize publication notice on their own, but through the reason the whole thing is wrong is through the Federal Rule 4's incorporation of state law service provisions in the state where the federal district court sits and the state where the defendant is served. And Delaware here, according to the hypothetical, does allow service by publication in this situation. The federal rules of civil procedure would incorporate that by reference, and therefore this would be appropriate under the federal rules of civil procedure. But again, it's not possibly and probably going to be constitutional. Okay, so that was the constitutional part of notice, and then secondarily there's the statutory part, which is governed in the federal courts by Rule 4 of the Federal Rules of Civil Procedure. And so Rule 4 is a very lengthy rule. It is in terms of its provisions for service of process and the methods for service of process, it has for each type of entity, each type of defendant, the federal rules set forth their own methods of service that are, explicitly appropriate under the federal rules. And then the federal rules also incorporate the laws of service of process of the state in which the federal court sits and the state in which the defendant is served with process. So what do we mean by process? Process is defined to mean the summons and a copy of the complaint. So whenever we say the defendant is served with process, unless the defendant is served with a summons and a copy of the complaint, the process has not been proper. The process server must be a person who is over the age of 18 and cannot be a party to the suit. So in other words, the plaintiff herself cannot serve process. Sometimes you'll see multiple choice questions that try to trick you into agreeing that the plaintiff can serve process. And you'll know right away that that is a trick question. Okay. There is a time limit on service of process, which is set forth in Rule 4M, and the presumptive period, the presumptive amount of time that a plaintiff has to serve process on a defendant is 90 days from the filing of the complaint. Now, we did talk about how in your casebook, which was printed before the later amendments to the Federal Rules of Civil Procedure went into effect, in other words, up until December 1st, 2015, that time period was 120 days. It is now, since December 1st, 2015, 90 days. So the casebook is incorrect in that regard, but your statutory supplement is up to date, and that says 90 days. This provision, or excuse me, this amount of time can be extended for good cause. Actually, Rule 4M is rather confusingly drafted in that regard, and it does contain a hint of a suggestion that the period could even be extended without good cause. But of course, it's never a good idea for a plaintiff to have to throw themselves on the mercy of the court and ask for additional time. Now, if you as the plaintiff do not serve the defendant within the 90 days, the possibility is that the court will dismiss the case. In fact, the rule says the case must be dismissed, and that is without prejudice, of course. However, if your statute of limitations has run in the meantime, a dismissal without prejudice might as well be a dismissal with prejudice. So that's something you want to be very sure of accomplishing if you are running tight on the statute of limitations. Okay, so the methods for service, again, are set forth in Rule 4, and the method depends on the type of entity that the defendant is. So first of all, if it is an individual person within the United States, that's going to be governed by Rule 4E. And of course, personal in-hand delivery of process is always going to be fine. In the case of an individual person, you can do what is called substituted service, which is delivery of the summons and complaint, the process, at the defendant's dwelling or usual place of abode, with someone of suitable age and discretion, and that someone has to reside at the defendant's dwelling or usual place of abode. So those three elements must all be met. Now, looking first at a person's dwelling or usual place of abode, the key provision in the case law interpreting that is that there must be some indicia of permanence to this place. Now, as we talked about when we did subject matter jurisdiction, an individual person can only have one domicile for purposes of diversity jurisdiction. However, a person can have more than one dwelling or usual place of abode under Rule 4E. And so that's what the court, so if you have, say, a vacation home that you own, certainly, and you go there every year for the summer, that's probably going to be considered one of your usual places of abode. The determination of the person being of suitable age and discretion, who the process server leaves the papers with, is also a factual determination. Remember, the Florida statutes have a bright line 15 years old rule. The federal courts do not have a bright line rule. And of course, whoever that person is, they have to reside there. So a housekeeper, a live-in housekeeper, can be a person of suitable age and discretion upon whom a process server can serve the substituted process if the housekeeper resides there. Now, if you can't comply with either of those two methods that's set forth in the federal rules for service of process on an individual person, then the federal rule also under 4E1 incorporates the methods of service that are authorized by state law of either the state where the district court sits or the state in which the defendant is served. So potentially this opens up the methods of service to first-class mail or other methods of service that are authorized by state law that the federal rules themselves do not authorize. So here's a multiple choice question on service of process. And once again, I will allow you the opportunity to pause this and read the question and decide what you think the answer is. Okay, so the question is just asking, in which of the following situations has service of process been properly effected under the federal rules of civil procedure? And the correct answer is B. Plaintiff serves defendant Dolly by having a process server leave the summons and complaint at Dolly's house with Dolly's daughter, who is a law student and lives with Dolly. So this is appropriate substituted service with Dolly's daughter. Dolly's daughter being a law student, one would certainly think that she would be of suitable age and discretion, and the answer stipulates that she lives with Dolly and that this is Dolly's house. So that's going to hit all of the requirements for substituted service. Now looking at the incorrect answers, A is plaintiff serves defendant Dolly by having a process server personally deliver the complaint to Dolly at her office. Okay, sorry about that. I had a momentary problem. So A, at first blush, looks like it's fine, right? But it doesn't say complaint and summons. So process is not properly served unless you have both elements of the process, which is the summons and the complaint. So if A had said deliver the summons and complaint to Dolly, then that would have been perfectly fine service of process, but it doesn't. C says plaintiff serves defendant Dolly by having a process server leave the summons and complaint with Dolly's daughter, who is a law student and lives with Dolly, at the law office where she works. So the federal rules do not provide for substituted service at any place besides the defendant's dwelling or usual place of abode. So you can't sort of track down their daughter where their daughter works. Remember, the policy behind the rules is to attempt as much as possible to make sure that the defendant receives actual notice. And the farther away you get from leaving the papers at the defendant's home, the farther away you get from being pretty sure that the defendant is going to get actual notice. Now, the service that's described in C may be authorized by some state statute somewhere, but it is not authorized by the federal rules of civil procedure unless they were to incorporate that state statute. And D, of course, is wrong because only B is a correct answer. Moving on to service of process on a business entity, like a corporation or a partnership, or indeed any entity that may be sued in its own name. We'll break this down as well between service that the federal rules of civil procedure explicitly allow for, and then the state service of process methods. So under the federal rules themselves, under 4H1B, the way you serve process on an entity is to serve. The rule uses the word deliver, and remember we talked about that, where deliver means serve, means personally handing. It does not mean mailing. So you serve or deliver process in the United States on either an officer of that entity, a managing or general agent of that entity, or any other agent authorized by appointment or by law to receive service of process. So, for example, corporations to do business in a state frequently are required by state statute to appoint someone to receive service of process for that corporation. And in the absence of their appointing anyone, they are deemed to have appointed, say, the Secretary of State of that state to receive service of process for them. So 4H1B allows service on those either designated or deemed agents for service as well. And then the latter part of this is one that is frequently confusing to students. It says, and if the agent is one authorized by statute and the statute so requires, by also mailing a copy of each to the defendant, meaning each the summons and complaint. So this only applies if, number one, the agent that you're trying to serve is an agent that is authorized by law, by state statute, which would be the example of, say, the Secretary of State that I just gave. And if that statute so requires a plaintiff to do, then you must also mail a copy of the summons and complaint to the defendant, in addition to serving the Secretary of State in my hypothetical. If you don't do that, the federal rules also, through 4H1A, incorporate the methods of state service, again, of the state in which the federal court sits and of the state in which the defendant entity would be served. And so the roundabout way that 4H1A says this is in the manner prescribed by Rule 4E1 for serving an individual, which if you go to 4E1 is simply the language that incorporates the state methods of service. I think I see that this video is becoming almost a half an hour in length, and so I'm going to end the notice part and the service of process part here and make a separate shorter video for waiver of service. So I will be back with you shortly. Have a good evening or a good day.